Ready? Start. Now we choose to consider the intent and object of the scheme. Though incorporated with reference to a fiscal statute, it does not create a charge or levy of tax. Rather, it represents and implements the Union government's policy to reduce legacy litigation involving disputed levies of indirect taxes under 28 specified indirect tax enactments under section 122A and B of the scheme and any other enactment that may have been notified for that purpose. To end such legacy litigation, the scheme first lays down strict eligibility under section 125 of the scheme. Stop. Undisputedly, the present petitioner is eligible to apply for issue of the discharge certificate. Stop. The scheme provides for legacy dispute resolution upon payment of 30 to 60% of the disputed demand of tax dues by virtue of section 123 of the scheme. Tax dues are total disputed amount of duty only. Stop para. Thus, the litigation seeks to reduce indirect tax legacy litigation against positive payment of a part according to the predetermined rates of the disputed dues of tax. Stop. Remarkably, the scheme requires the applicant oblique assessee to pay part of the disputed dues or tax even to obtain closure to any appeal filed by the revenue. Stop. Also, the legislation is not an amnesty scheme to encourage voluntary disclosures of hitherto undisclosed evaded taxes. Stop. Rather, by virtue of section 124(1)(e) of the scheme, it purposely denies any relief to persons who may have made a voluntary disclosure. Stop. Clearly, the scheme is a reform legislation. It seeks to end old or pending indirect taxes disputes against payment of a substantial part of the disputed tax amount. Stop para. While interpreting another reformatory legislation involving land laws in R.E.M.S. Abdul Hameed versus Govindaraju and others 1999 4 SCC 663, the Supreme Court considered whether a minor inam came within the purview of the Tamil Nadu Minor Inams Abolition and Conversion into Ryotwari Act 1963, or it would fall under the Madras Inam Estates Abolition and Conversion into Ryotwari Act 1963, hereinafter referred to Act 26 of 1963. In the reformatory nature of the Act, the Supreme Court relied on the intention of the legislature to include all inams. Stop. It further opined that any exclusion claimed must arise on unimpeachable evidence and not ipse dixit. Stop. It was thus held para, returning to the present case to be out of Act 26, the area of grant to the appellants should not constitute to be a part village state, and for this the appellants have to prove that its grant was expressed only in terms of acreage or coins, etc. Unless this is shown, exclusion from the Act cannot be gained. Looking back to the history of legislation of Inam Estates, the intention of the legislature was to encompass all Inam Estates within its fold, and small exclusion is made. Hello.